Good evening to everyone. Am I audible, ma'am?
Yes, sir. You're audible, sir.
Good evening to everyone. On the behalf of Internal Quality Assurance Cell of Mahatma Phule Mahavidyalaya, Kingaon, I heartily welcome to all the respected teachers and all the dear participants. I'm very much thankful to Dr. B.R. Bodke sir for chairing this session, the principal of my college. I'm very much thankful to the today's chief guest, Honorable Vice Principal of my college, Dr. Vittalji Chavan sir, for being with us. I am very much thankful to the today's resource person, Mrs. Sangeeta Verma, ma'am. Ma'am is working as an assistant professor at Ajinkya D.Y. Patil University. She has published so many research papers in reputed journals. She has also participated in various national as well as international conferences. Not taking much time between you and her, I welcome today's resource person to deliver her talk. Welcome, ma'am.
Thank you, sir. Thank you. So, very good evening to one and all on this platform. I firstly would want to take this opportunity to thank me for giving me this opportunity to be here. With everyone's permission, can I share my screen?
Yes, ma'am. Yes.
Is my screen?
Yes, ma'am. It is visible. Yes, ma'am. Visible.
Right. I am basically a faculty of law. And I am working, like sir mentioned, I'm working with Ajinkya D.Y. Patil University, and I'm into academics for last 7 years, and I'm currently pursuing my PhD. So the topic which I have taken to be discussed on this platform is with respect to, the essentials of a valid contract. Now, let me make this thing very clear. Though I'm taking a topic which is a law subject, but I know this fact that the various participants on this platform are from various disciplines. So what I'm going to do is I'm going to keep this simple, because see, when we talk about a contract, it is not something which only law students or law faculties or lawyers or advocates should know. When we talk about a contract, this is something where each and every person in our daily routine, we enter into several contracts, right? But when I'm discussing this particular topic in the law perspective, here basically we need to understand what are, the various essentials which has been laid down by virtue of, the legislation which I'm going to discuss. That's your Indian Contract Act. Yeah. So, like I said, that, even, a lay person, in his, daily routine, he enters into the contract. So basically, right from, let's take a very simple example that, when I, book a ticket, for a train ticket for my journey, there also I am entering into a contract, right? Or let's say we ordinarily go and we do shopping, we purchase certain articles. What are we doing? We are entering into a contract there also. So by virtue of this contractual obligations, there are certain rights which are created. Not only rights. See, we all know this fact that when we talk about rights and duties, these are the two sides of the same coin. So when I talk about right, there is simultaneously some duty which has to be performed by the other party. So is the case when you're talking about, a contract also. If by virtue of, the obligations, the contractual obligations, if there is a right which has been created in me, in any person, there is going to be a reciprocal duty which will be imposed upon the other party. Now, like my topic is saying, essentials of a valid contract. So here, today we'll try understanding that what are, the various provisions which has been laid down by virtue of, your by Indian Contract Act, wherein we will see that there are n number of things which has been listed. Now, I think for a lay person, when we talk about an agreement, or when we talk about a contract, probably that may sound similar and it may be a synonymous term. But let me tell you, when you actually read the Indian Contract Act, you would understand that an agreement and a contract is not the same. See, when we are talking about an agreement, if you can see on my screen, I have put in that it is the Indian Contract Act 1872, which is basically governing the contracts which take place or which are being entered into in India. So basically the rights and the obligations would be governed by this Indian Contract Act. Now I have stated agreement plus enforceability is contract. So I'm trying to explain here that when you talk about an agreement, an agreement need not be a contract. Why and how? Let me explain this. See, when you talk about an agreement, in our day-to-day life, so let's say I, enter into an agreement with my friend, I make a promise to my friend, and I tell her that, we'll catch up for dinner tonight. All right. And due to some emergency, what happens is I'm not able to make up for the dinner, and I'm not able to fulfill that promise. Now the question is, if we are saying that I have entered into an agreement with my friend, do you think that the friend can sue me, or do you think that the friend will have certain rights which can be enforced against me? No. Why? Because this agreement which was being done, that was something which was entered into without there being any legal intention so as to enter into a contract. So in my subsequent slides I'll come to it, that you need to have that legal intention if you really want to enter into a contract, right? So in this kind of example which I gave, we know that there cannot be an enforceability of such agreements. So when I say enforceability, what I mean by the term enforceability is that you will not have a remedy against such a person before the court of law. So only those agreements where we can talk of the enforceability, those are the ones which are termed as contract. I'm not going to get into very intricate details or the provisions which has been laid down. My attempt would be to keep it simple so as to make a non-law person also understand. So the basic things which I mentioned. Now, Section 2 clause H. So basically, Section 2 of your Indian Contract Act is a definition clause. And if you look at clause H under that, it basically defines the contract whereby it has been provided that an agreement enforceable by law is contract. This is what I was trying to explain. That only those agreements where you have the enforceability, those are going to be the one which will be termed as contracts. Now again, when we talk of contracts, contracts could be an oral one, it could be a written one as well, right? So not necessary that it has to be a written one. Of course, when we talk about important contracts, or the contracts where you have a lot of money which is being involved, you can't think of having such contracts in an oral way, right? Because we always, when we talk about law, we always look out for certain evidence, that if God forbids something happens in the future, you know that there is evidence in place. So it is always advisable that we have the written contracts. Now, this particular slide is talking about the first component or the first essential when we talk about, a contract. So if you want to have a valid contract, the first thing which has been provided is that there should be an offer, right? An offer is also termed as, the proposal. So when you talk about the formation, in first place, there has to be an offer. Again, if we look at the definition clause, Section 2 clause A is basically defining what an offer is, right? So instead of, reading the definition, let me directly explain, what we mean by an offer. So basically, it is a proposal. When one person is trying to make an offer, a proposal to another party, it is said that an offer has been made. So let me give a very simple example. So if I say I have a cell phone and I'm intending to sell my cell phone to Mr. X for rupees 30,000. So here, what am I doing? I am putting forward a proposal to Mr. X whereby I am expressing my intention that, I want to sell this. So are you ready to purchase this? So what am I doing here? I am putting an offer before the other party. So when we talk about offer, there are two terms which we use. The parties are referred to as the offerer and the offeree. So the one who makes the offer is called as the offerer. The person to whom you are making the offer is called as the offeree. So now here, the highlighted portion which you can see on my screen, the intention of creating the legal relationship. So this is what is important, and which this is something which I mentioned in my initial slide also. What is important is that if you talk of having a contract, primarily there has to be an intention so as to create a legal relationship. So like I said, that if I make a certain promise to my friend, that I do not intend, when I'm talking to my friend or when I'm making a promise to have a certain legal relationship, and therefore there is no enforceability, right? There will be an enforceability only with respect to those agreements where there is a legal intention, right? So legal intention is very important when we talk about an offer. Moving forward, the essentials of a valid offer. So what is necessary when I'm saying that, in first place, there has to be offer, but this offer also needs to have, certain components so as to say that, it is, a valid offer. So the first part is that there has to be the communication of such offer. It's very simple, right? If I am saying that I want to, sell my cell phone to Mr. X for rupees 30,000, for sure I have to communicate this, or else how do we know that, the other person is aware of, the offer which I'm making? So there has to be a communication to the other person, to the offeree. Now, when I am making such an offer or I am putting forth such a proposal, I am doing it with the view so as to obtain his assent. So when I'm saying, assent, what does assent means? So it means basically the consent. When I am putting forth an offer to the other person, I am wanting the other person to give his consent to the same, right? Now the offer which I am putting forth, that has to be definite and that has to be certain. So what do I mean when I say it has to be certain? It should not be ambiguous. There has to be clarity with respect to the offer which I am making, right? So let's say if I possess 3 cars and I say I want to sell my car, okay, I put forth this offer to Mr. X that I want to sell my car. Now in this kind of example, I have not expressly stated which car is that, right? Which car is, I am wanting to, sell. It's just a very general statement, which is, ambiguous in nature. So I have to be very certain. I have to be very specific which car I'm wanting to sell to the other person, right? And like I already discussed, there has to be an intention to create a legal relationship. Without that, we cannot have, a valid offer. There is another thing which has been stated that, if I'm making an offer, I cannot say that if you do not reply to my offer, I'm going to take it, to be, a yes. So if I'm putting forth, the offer that I'm going to sell my cell phone to Mr. X for rupees 30,000, I can't put a term or I can't put a condition whereby I'm saying that if you do not reply to this, it means that, you have accepted my offer. No, I can't do that. So the non-compliance, it can't be taken to be, a ground for accepting that offer. So now, since I've introduced this term acceptance, my next slide will also talk about, the acceptance. Now, okay, I think, it's not there. All right, acceptance here. So what is acceptance? So I have put forth a proposal and, you are giving your consent to it. So acceptance is the final and the unqualified expression of assent to the terms of an offer. So basically, it is nothing but the consent which you are giving. So you are basically saying that, yes, I'm interested, I will purchase the cell phone. So again, here, once when you are giving your approval, your consent, your acceptance, there has to be communication. So if I have made an offer, you should be communicating your acceptance. Now, like we discussed about, the essentials for a valid offer, we have the essentials for a valid acceptance also. So what are the essentials here? That it has to be absolute, and it has to be unconditional. So what does this mean? It basically says that, if you are giving an acceptance to the offer, you can't be imposing conditions on it, right? You can't be saying that I will purchase this if this. So you cannot have, conditions which can be subjected to such an offer. Obviously, there has to be the communication of, the offer. Now, the next point which I have mentioned, that it has to be made in the manner which is prescribed. So let's say when I make this offer to you, and I am putting up a condition as an offerer that you will have to give your acceptance by a telephonic call. So here, what I have done, I have given you a manner by virtue of which you will have to necessarily communicate, the acceptance. So if I have prescribed a particular manner, you will have to give your acceptance as per this manner only. And another essential which is required is that it has to be given within the time prescribed. So if I have made an offer to you and I say that you will have to give your acceptance within a period of 1 week, आपको एक हफ्ते में communicate करना है, तो आपको एक हफ्ते में ही communicate करना है. So the moment, this period of 1 week passes, this offer will no more be open, right? So if there are certain
କାଲିଠୁ ସରିଲାଣି ନଥିଲା ଆମେ ଜଗୁଆଳ ହେଇକି ଥିଲୁ ତାଙ୍କର କରୁଥିଲେ ସେ ଅଲଗା ହିଷ୍ଟ୍ରି ଆଉ କି ହିନ୍ଦୀ ଗଲା କରୁଥିଲେ ତ ତାଙ୍କର ଆମର କ୍ଲାସ ନାହିଁ କିଛି ନାହିଁ ତାଙ୍କର ଖାଲି ବାସନ ମଜା ହବ ତାଙ୍କର ଗଲେ ଆମେ ବସିକି ଜଗିଛୁ ସରିଲେ ଆମେ ତାଲା ପକେଇ ଆସିବୁ ହଉ ଭଲ ହେଇଛି ଆମର କାଲିଠୁ ସରିଯାଇଛି ଘରକୁ ପଳେଇବେ ଆଜି ଘରକୁ ପଳେଇବେ
so it has to be given within the time frame which has been mentioned. Now I have put in a note wherein I have said that an acceptance with variation.
କଲେଜର ପିଲା ସାର୍ ରହୁଛନ୍ତି
So like I said,
କଣ ପାଇଯାନ୍ତି ହଉ
if you are subjecting it to certain conditions, अगर आप
ଗଣେଶ ମୁଣ୍ଡେ ଭଲ ନାଇଁ रे
कंडीशन लगा रहे हो, तो इसका मतलब ये नहीं है कि आपने हमारे ऑफर को एक्सेप्ट किया है. This basically means that you have in turn given a counter offer to me, right? So once when you are making a counter offer, I am the one who has to accept this offer. So here, when the acceptance has to be given, it has to be a clear acceptance without subjecting it to any conditions. So we have seen two elements so far, that if you want to have a valid contract, primarily there has to be an offer. Then the other party has to give the acceptance to, the same. Now, I have also taken, one slide which is talking about the revocation of the offer. What is revocation? Revocation is nothing but cancellation. So I have mentioned, the modes. What are the various modes by virtue of which the offer can be cancelled? So like I said, if I have said that I want to sell a cell phone to you for rupees 30,000, and let's say I am no more interested. So if I want to do so, I want to cancel the offer, I will have to communicate to you. How will I communicate? By virtue of a notice, right? So I have to give a notice to you. Again, if I have kept my offer open for, let's say, a week, and if you have not communicated your acceptance, so after the period of that, 1 week, the offer will lapse. If the acceptor has failed to fulfill the condition, so like I just discussed under my acceptance, that you can't be subjecting it to conditions, you being an acceptor or being the offeree. Here, it is the offerer who will, subject it to certain conditions. So if I have subjected the sale to certain conditions, and if you do not comply with those conditions, then, the offer will stand revoked, it will stand cancelled. Similarly, the death or the insanity of the proposer. If I am the offerer, let's say I made the offer and before, there is an acceptance which has been given to it, I die. So in that particular scenario also, the offer will stand cancelled, the offer will stand revoked. But what is important, what does the law say here? That be it the death or be it the insanity. When I talk about insanity, an insane person is a person who does not have the mental capacity to think as to what are going to be the consequences, right? So Be it the insanity or be the death, what is important is that it should be in the knowledge of the acceptor. And again, another mode or the circumstance by virtue of which the revocation can take place is the counter offer. So like I gave you an example. If I am saying that I'll sell the cell phone to you for 30,000, you say no, I will buy it only for 25,000. सो आपने क्या किया, आप नेगोशिएट करने की कोशिश कर रहे हैं, तो हम जो आपको ऑफर दे रहे हैं आप उसको एक्सेप्ट नहीं कर रहे हैं, आप इन रिटर्न क्या कर रहे हैं, आप इन रिटर्न एक काउंटर ऑफर दे रहे हैं, आप हमें काउंटर ऑफर दे रहे हैं। अब ये जो आपने काउंटर ऑफर दिया है, अब हमारी बारी होगी कि हम इस काउंटर ऑफर को एक्सेप्टेंस दें, right? So here the counter offer is another way or mode by virtue of which the revocation can take place. Now, another important aspect is consideration. See, we all know, nobody would, want to enter into, a legal contract without there being, the consideration, right? So money is very important. So here, the law also says that one of the essentials for, a valid contract is that there should be consideration in it. So when I talk about consideration is nothing but it is the price which is being paid to the party. Now, obviously, when I am selling a cell phone to Mr. X for 30,000, in return, I am expecting rupees 30,000, isn't it? And when I am expecting 30,000 from him, I am supposed to be handing over the cell phone to Mr. X. So what is happening? There is an exchange which is taking place. So this is what the consideration is. When I am receiving the money from Mr. X, that is consideration for me. What is going to be the consideration for Mr. X? In return of that money which he's paid, I am giving the cell phone. So that cell phone is going to be the consideration, right? So consideration is nothing but it is something in exchange. Now, another important aspect which has been mentioned under the Indian Contract Act with respect to consideration is that it is not necessary, nowhere the law is saying that the consideration has to be of the equal value for the article or for the product or for any services which you are rendering. So let's continue with the same example. So if I'm saying that I am ready to sell a cell phone to Mr. X for 30,000, maybe the original price of that cell phone is 50,000, but I wish to sell it only for 30,000. So it doesn't mean that this contract which we are going to enter into, that will not be a valid contract. So the only essential aspect with respect to consideration is that it should have some value. In the eyes of the law, it should have some value. Now again, when you're talking about consideration, it is again not necessary that it has to be only in monetary terms. It could be anything. It could be goods in exchange. It could be certain services in return. The point is that it should have certain value. Another aspect which you can see on my slide is where I have mentioned section 25. So this is basically the general rule which has been laid down under section, under Indian Contract Act. So section 25 basically says that an agreement without consideration is void. So let me introduce this term void, for people who are from the other disciplines. When we talk about void, void means it has no value in the eyes of the law. So right from the beginning, the another term which we use is void ab initio. So it is a nullity right from the beginning. That is how we use it in law, right? So if there is an agreement which is being entered into without there being any consideration, it is termed as void agreement. However, let me emphasize this. However, there are certain exceptional situations where an agreement, where a contract which is being entered into without there being any consideration, it will still be a valid agreement or a contract. For example, I have mentioned here gift deed. We all know what a gift is. हम अपने फ्रेंड को गिफ्ट दे रहे हैं, obviously ये गिफ्ट है तो हम in return कुछ expect नहीं करते हैं. So let's say if there is a gift deed which has been made in my favor, it is without any consideration, still it is a valid one, isn't it? So then there are certain exceptions which has been laid down under the Indian Contract Act, where it says that even without a consideration, such agreements or contracts are going to be a valid one. There is another term which I have used as gratuitous bailment. So bailment is nothing. Bailment is where you are delivering goods to another person for a certain purpose. So the moment that purpose is achieved, those goods are to be returned back to me, right? But here, when I am, giving the goods for a certain reason, that other person is not going to charge money from me. It is going to be a gratuitous one. The term gratuitous basically means, right, which is out of love, which is out of affection. So gratuitous bailment is another example whereby, even there being no consideration, it would be a valid one. Another very important factor or element for a valid contract is that the parties should be competent. So when I say competent, I think we all understand who's a major and who's a minor. So the law says that the party should be a major one. Not only major, the person should be of a sound mind. The one who's entering into a contract, he should be of a sound mind. He should be in a position to understand the nature of the contract he's entering into. He should be able to understand, what are going to be the consequences of such contracts which he's entering into, isn't it? So your section 11 of, Indian Contract Act, it is basically laying down that minor he is not competent to enter into a contract. Whatever agreement is being entered into by a minor is going to be a void one. See, the best part about the Indian Contract Act here is that, let me specify that the Indian Contract Act nowhere is saying whether such contracts are going to be void or voidable. Explicitly, there are no terms which are being used here, right? However, this dilemma with respect to, whether such contracts are going to be merely void or voidable, that is being raised by, this particular landmark case, which is Mohiri Bibi versus Dharamdas Ghosh. So there are n number of cases which I could have discussed, but I have, kept my presentation simple so as to cater to the needs and the understanding of, attendees from various disciplines. So here I have just mentioned this particular case so as to point out that it is this case whereby it was held that whatever agreements are being entered into by a minor are going to be void one. However, again, like we did in consideration, there are certain exceptions. So see, we are all aware that, when you talk about a partnership, partnership agreements जो होते हैं, minor को वहाँ पे admit किया जा सकता है, केवल benefits के लिए किया जा सकता है. So again, such agreements which are being entered into by minor, those would be, valid one. That is one of the exceptions. So I have just taken this example so as to point out that, there could be a scenario where even a minor who's entering into, a particular agreement can be a valid one. However, we all know that you cannot impose, liabilities against, the minor. But the agreement which is being entered into with a minor can only be for his benefit. So the next one, the consent and the free consent, that's another very important element or essential for a valid contract. The consent which has been given by, the parties, that has to be a free consent. So there is this term which we use in law is consensus adendum. So what does this term mean? It basically means that, the consent which is being given by the parties, that consent has to be out of, your willingness. You have to consent at the same time. There has to be meeting of the minds which should take place. That is one of the essentials. And what this free consent is, again, that has been defined under section 14 of the Indian Contract Act. So it basically, if you can see the elements which I have listed, the coercion, undue influence, fraud, misrepresentation, mistake. So these are the various elements. So basically, the Indian Contract Act is saying that if the consent is being obtained by virtue of any of these elements, it will not be taken to be a free consent. So this brings us to another question. What is that other question? That what are these particular terms which I have mentioned? So I will try to explain it in the simplest form. Now, when we use the term coercion, so what is coercion? Coercion is basically where you are trying to threaten the other party. So let's say if, you are wanting to enter into a contract with the other person and the other person is not willing to do so, what you are doing is you are threatening that other person and you are threatening to do certain act which is forbidden by the Indian Penal Code. which is forbidden by the Indian Penal Code, which it basically means that it is considered to be a crime under the Indian Penal Code. It is forbidden. आप ये नहीं कर सकते, right? If I am threatening you that I will commit murder, so that is something which you can't do, right? So here, if I am creating a threat, if there is imaginary terror which is being created in the mind of the other person, that I'm going to do so and so act, and that act is prohibited by virtue of IPC, then it is said to be coercion. See, it is not necessary that there has to be an actual violence which has to be used. What is important is that merely the threat, वो एक डर, अगर आप सामने वाले के माइंड में क्रिएट कर रहे हो कि मैं आपके साथ under coercion of the person giving consent, that is not a legal. And this brings us to another question. So let's say if such kind of consent has been obtained, the other party has signed the contract, but it is under coercion. It means that such agreements are going to be voidable. So let me explain this term voidable. In law, we use three different terminologies: valid, void, and voidable. So like I said, void matlab hai कि उसे कोई अहमियत नहीं है, that's null actually. And when I talk about voidable, voidable has been explained, whereby it is said that it is at the discretion of the party at whose consent you have so obtained, either by coercion or either by fraud or whatever, that party can avoid the contract. So अगर वो चाहे तो वो contract या agreement को वहीं पे खत्म कर दे, या तो अगर उसकी इच्छा होगी तो he can go ahead with the contract. So that is what coercion is. Moving forward to the next term, that the consent should not be by virtue of undue influence. So I think we all understand the term influence. Influence basically means that you are trying to exert certain power on the other person. So here, when we are talking of undue influence, it basically means that one party who is in a stronger position, he or she is trying to dominate the other person who's considered to be weak, right? Now, if we look into the provisions, section 16 is giving the essentials for the undue influence, right? Now here, the relation which is there between the parties, that has to be such a position whereby one party can dominate the other party. So let me give you an example. So let's say if I am a doctor and Mr. X is the patient. Now I know that Mr. X is suffering from certain diseases which is not to be disclosed into the society. Now here I am wanting to enter into a contract with such a patient, and it is by virtue of undue influence that I'm making him sign in the contract. Now here in such a scenario, by virtue of law, there will be a presumption which will be raised that yes, since I am a party, or the relationship which I'm having with Mr. X is such a relationship where there can be the domination of the other party. So certain relationship, which are considered to be the relationship where there is a fiduciary aspect which is coming in, where fiduciary basically means a relationship of trust, right? So if I am an advocate and Mr. X is a client, again that relationship is a relationship of trust. So in such kind of relationship, there is a presumption which is being raised by virtue of law, whereby it is said that there will be this thing presumed that yes, the party, let's say the doctor or the advocate or the teacher, they have dominated the will of the other. So here basically we all know, that such presumptions which are being raised, those are always rebuttable. But I'm just trying to make a point here that in the case of an undue influence, the presumption will be raised and it will be in favor of the other party whose consent has not been so obtained freely, right? And again here, what is the consequence of such an agreement? Such agreement again is going to be voidable, and I have written here, at the option of the party whose consent was so caused at so caused. So now here, moving forward, this is the next element, fraud and misrepresentation. Now let me deal with misrepresentation first. As the term is suggesting, mis and representation. Representation is nothing but, we try to put forward a certain fact, right? And when I use the term mis, means the facts which are being put forth to the other person, those facts are incorrect. There is falsity in, that representation. But in misrepresentation, it is basically an innocent statement which you are making, which means that you don't intend to, deceive the other party, but inadvertently it is happening because you yourself are not aware of, the real fact. So if you can see the example here, A sells a horse to B, which is unsound, but A himself does not know this fact. So what is happening here? Here, though A is selling this horse, which is of an unsound mind, but unfortunately, Mr. A himself is not aware that the horse is of an unsound mind. So यहाँ पे क्या हो रहा है? जो हॉर्स के बारे में जो फैक्ट है वो ए को नहीं पता है, इसलिए वो गलत तरीके से बी को बताया जा रहा है. बट यहाँ पे ए जो है वो इंटेंशनली नहीं कर रहे हैं. It is just inadvertently that it has happened, right? So the point is, when we are talking about misrepresentation, there is no intention as such to deceive the other party. So there is a false representation, but that false representation is done innocently. It is just the opposite when I talk about fraud. What is fraud? We all know, where the person would have an intention to cheat upon the other person. The person would have an intention to deceive the other person. So under fraud, there is an intentional misrepresentation which is happening. So the representation which is being made, it has to be with the knowledge that yes, this is false, this is not correct. So there are two terminologies which are being used, certain Latin terms. So it is suggestion falsi and suppressio veri. So what does this mean? Suggestion falsi is nothing but you are making a suggestion which is incorrect, suggestion of falsehood. Similarly, when I use the term suppressio veri, it basically means I am trying to suppress certain fact, which means that I know the fact, but what am I trying to do? I'm trying to hide that. I'm trying to suppress that. So if the consent is being taken under these kind of circumstances, where there is a misrepresentation or where there is a fraud, then the consent is said to be not a free consent. Similarly, when you talk about a mistake, we all understand, mere se ye galti ho gayi, mere se ye mistake ho gayi, right? So now, though it is a mistake, but this mistake could be, an unilateral one, it could be a bilateral one. So when I say it is a bilateral mistake is जहां पे by दोनों parties की गैर समझ हो रही है. Whereas when I talk about a unilateral mistake, there is only one party who's mistaken. So if there is one party who's mistaken, the agreement is not going to be impacted or is not going to be affected. However, if that mistake is a bilateral one, it is the agreement which is being entered into is going to be a void one. Why? Because there is a cross purpose which is taking place. So for example, if I say I want to sell a car, which is X car, since I am possessing two cars, X and Y, I have said that I'm going to sell, an X car, and you are taking it to be a Y car. But when I sold, I have this that yes, he's understood. So यहाँ पे क्या हो रहा है? There is a mistake from both the sides. So in case if there is a bilateral mistake, there is no consent at all, and therefore such agreements are going to be a void one, void which will have no meaning. There is no agreement in place. Now I have mentioned that there are two types of the mistake. One is called as the mistake of fact, and the other is called as the mistake of law. So mistake of fact is basically where, certain facts, the information, the details. So like I'm talking about a particular product. So this product, इसके features हुए, इसके qualities हुए, इसके बारे में जब हम बात कर रहे हैं, वो fact है. So those are very essential. So if there is a mistake of fact, the agreements are going to be, void one. However, when we talk about mistake of law, that is no excuse. I give you a simple example. Let's say I start, driving a car and I don't take a license. So if I'm caught by the policeman at the signal, I cannot take an excuse that I am not, I didn't know that, there is a law which says that I have to, be having a license for driving. I'm just taking a very vague, example. So here I'm trying to make a point that, you can't have an excuse that you are not aware about law. You are supposed to be knowing the law. It is presumed that you know the law, right? However, if it is pertaining to, some foreign law, obviously you are not expected to know the foreign law. But if it is an Indian law, with respect to, these minor things, you are expected. So a mistake of law can be no excuse. So that's another aspect whereby, the agreement will not be a valid one if it is, the consent has been given by mistake. Now, when I talk about lawful object, this is something which is very important. See, obviously, when two parties enter into an agreement or enter into a contract, there is a reason as to why you're entering into a contract. Now, that reason or the object for entering into the contract cannot be an unlawful one. हम अगर कोई कॉन्ट्रैक्ट एक्स के साथ कर रहे हैं, हम किसी इलीगल ऑब्जेक्ट और पर्पस के लिए नहीं कर सकते. I can't be saying that Mr. X go and murder Mr. Y and I will pay you 5 lakh rupees. So let's say I have, we both have agreed to do so. Mr. Y is going and, killing that other person. And when he comes and I say that, I will not pay you the amount. So in this kind of scenario, this Mr. Y, he cannot go to court and he cannot, sue me to have certain relief against me and say that, she had promised to give me 5 lakh rupees. Obviously, this can't be done. Why? Because the purpose or the object of, such a contract or an agreement was unlawful one. It was illegal one. And another thing, that if you're entering into any contract, what is important is that the agreement should not be declared to be void. So could be under any law. अगर किसी भी law के under में ये agreement prohibited है, तो आप ये agreement नहीं कर सकते हैं. So that is what a lawful object is. My purpose of bringing this particular topic in this subject is that because we all somehow enter into contracts on a daily basis. Let me give you an example. The slide is when we visit a particular website, there are certain terms and conditions which you have to take and you have to check that box. So that is nothing but again there we are entering into a contract. The online shopping which we are doing, that is also a contract. So we as a lay person, we all should be aware of what a contract is when we are entering into. So technically speaking, these different topics, these are chapters in itself, but I have tried my best to just simplify it so that I could bring down the essentials and I could meet the time requirement also. So this is all from my side. Thank you so much everyone for listening to me and giving your valuable time. Thank you, sir. So that is
Thank you so much.
Thank you.
Thank you so much, ma'am. It was really nice, wonderful presentation from your side. It was very informative and knowledgeable session that you have very nicely presented your topic. Thank you so much for accepting our invitation as a resource person and being here and giving your valuable talk to us. Thank you so much. I am very much thankful to Honorable Chairperson of today's session, Dr. B.R. Bodkesar, the principal of my college. Also, I am very much thankful to the vice principal of my college, Vittalji Chauhan sir. His sir is in this session with us from the since beginning. I also am very much thankful to the Dr. Balaji Degole sir, the assistant professor at Shivajagriti Mahavidyalaya Nalegaon. Sir is with us. I'm very much thankful to the head of the Department of Public Administration of my college, Dr. Sanjay Ji Jagtap sir, for being with us. Thank you so much, sir. I'm very much thankful to Dr. Kendra madam, Kendra KK madam. Ma'am is also with us. Dr. Abdul Basir sir, Tushti Sharma ma'am is with us. Then Lalita Bahera madam is with us. Then Anil Kumar Kanade sir with us. Then Shamin Akhtar sir is with us. Dr. Poonam Sharma is with us. I'm very much thankful each and everyone who are with us for this very nice session on the law subject. And thank you so much. And thank you so much, Dr. Sangeeta ma'am, for accepting our invitation and giving your valuable talk. Thank you so much. With the permission of chair, I conclude this meeting. Thank you so much, ma'am.